Minutes, let everyone sign in. And please sign to the attendants when you can. Okay. All right, I think we are ready. Everyone hear me okay? Just give me a thumbs up. Excellent, like I like to see. Okay, the attendance is on. Please sign into it when you can. I think most of you have already signed in. Any questions before we get started? Anything on your mind? Any questions? One more person joining in. Last call for questions before we get started. Okay. All right, let's do a poll question then. Okay, property one, resume. Okay. So here's your question. It should bring you back some memories from a few weeks ago. Blackacre from lessor to lessee for 1 year, beginning October 1st, then to A and his heirs. What interest does A have? A, reversion, B, remainder, or C, none of the above? What does A have? A reversion, a remainder, or none of the above? All right, let's see you guys take some time to think that one out. For those of you who just entered the classroom, we have a poll question going, so please take a look at that on your phones. Okay, we have about 56 of you putting in the answer. If you haven't, just let it keep going. If not, we'll move on. Another 10 seconds. I suspect that iClicker is also having capacity issues, which is why things aren't working as well as they ought to. And I apologize in advance if my connection drops. It doesn't happen with my night class, but with my day class, the connection drops intermittently. And I have a very fast package from Comcast and still has problems, so we're doing the best we can. Okay, let's stop it right there. Who's up next?
I am.
Jaleesa, is that you?
Yes, hi.
Okay. Jaleesa, so let's just go back to the question, right? And I'll read it one more time if you couldn't see it. It says, Blackacre from lessor to lessee for 1 year, beginning October 1st, then to A and his heirs. Jaleesa, just help us with terminology first. What's the difference between a lessor and a lessee?
The lessor is the person giving the land, and the leasee is the person taking it.
Okay, that's right. Because you remember the OR versus the EE, right? The EE ending signifies the person receiving, and the OR signifies the person giving. But Jaleesa, just be a little more precise. Is a lessor conveying land in fee simple?
No.
What is a lessor giving? Let's just be very precise here. Just look at the first few words, lessor, the first few letters. What do you think a lessor is giving?
Temporary.
What do you call that thing that you give? What's the subject of today's class?
A leasehold.
A lease, yeah, exactly. Yeah, you're right. You're overthinking it, I could tell. What would you call a lessor and a lessee in common everyday English? You know, the language that you and I would use in any everyday language. What would you call those two people?
A landlord and tenant.
Yeah, perfect. Exactly right. Thank you. In everyday common English, right? Right? In everyday common English, we refer to a lessor as a landlord, and we refer to a lessee as a tenant, right? This is, you know, how all of you speak of it. In fact, I'm sure that most of you have a lease. The landlord gives a lease to the tenant. Now, a lease is a special type of agreement. It's different from a conveyance granting fee simple, for example. It's different from a conveyance granting a life estate. It's different from giving out a contract of sale. A lease is a very specific agreement, and there are different kinds, which is what we'll be discussing in class today. Okay, so thank you, Julissa. I think, Ashley, you're up next.
Yes, sir. Can you hear me?
Yep, loud and clear. All right, Ashley, so let's go back to our question. Blackacre from lessor to lessee for 1 year, beginning October 1st, then to A and his heirs. How would we describe the interest? We'll get to the actual A in a minute, but what exactly does the lessee have? How would we describe his interest in Blackacre? What does a lessee or a tenant have? What do you call that?
Well, the lessee at that time would have like the present interest.
That's right, but how would we describe it? There's a specific phrase we use to describe.
A life estate?
Does it say he has it for life? Go back to the question.
No, just for that period of time.
And what do we call a lease for a specific period of time? What's that called from our readings for today?
Since it's just for that period of time, a fixed term would be a term of year?
Yeah, that's exactly right. In this case, the tenant has what's called a, thank you, Ashley. In this case, the tenant has what's called a term of years. And we know that it's a term of years because it's fixed. It ends at a specific point. But Ashley said something that was actually very helpful. She said it's like a life estate. It is in one regard. With a life estate, it will end at a specific date. Now, none of us know when we'll die. Thank God. We don't know. I don't want to know. Right? It'll happen. It'll happen. Hopefully later than sooner. But it happens at a specific point. But it will end, right? So all of us will die. We're all mortal. So then, Sarah, are you here?
Yes, I'm here.
Okay, so Sarah, my question for you then is what interest does A have in this scenario? Reversion, remainder, or none of the above?
Remainder?
Okay, why do you say remainder?
Because he's getting it for life, pretty much.
What do you mean?
So I don't know, is it a remainder in fee simple?
I'm not telling you anything. What is a remainder? Maybe it'll help if we review terminology. What's a remainder?
It's when the property is like given to somebody for forever, I think.
No.
Like there's not a fix. It's not not from like.
Give me an example, Sarah, of a remainder that we've studied 100 times. I won't make you go back to your chart if I don't have to, but I might have to, right? Give me an example of a remainder from a couple weeks ago.
Well, the most basic one is to A for life and to be in his heirs.
Okay, very good. From A to A for life and to B in his heirs, right? A has a life estate and B has remainder. Okay? How do we know that the interest that follows a life estate is remainder? What's the rule that we've discussed before? This is partially review, but it helps.
Can you repeat the question?
How do you know that a remainder follows a life estate? What's the rule that we used?
I can't remember the exact rule, but it's that point where it's like, well, what I use is when it says to their heirs too.
No? Okay, let's try another one. Anthony, you here?
Yes, I'm here.
So Anthony, let me ask you a question. What's the difference between a remainder and a reversion? You're chilling on the beach. Let's see if you can maybe get back in the flow.
A remainder is left to a third party, and a reversion is back to the grantor.
Okay, that's half right. You gave me maybe a 50% complete answer.
Okay.
It's true a remainder goes to a third party and a reversion goes back to the grantor, but when? When does a remainder go to a third party and when does a reversion go to the grantor? When? What's the trigger?
The end of the life estate. So the end of someone.
Okay.
The end of the,
Go ahead.
I was going to say the end of the present interest of the holder of the present interest. The end of the life of the present interest holder.
Okay, so that's like a 75% answer. We're getting closer, okay? So it's true. After a life estate terminates, if the interest goes to a third party, you call it a remainder. And after a life estate terminates, if it goes to the grantor, you call it a reversion. Anthony, I want you to finish your remaining 25%. You're almost there, right? You got 75, you got 50, 75, you're almost at 100.
Okay.
Do you always need a life estate? Or can a remainder follow some other type of present interest? I mentioned this point when we first did life estates almost a month ago. I remember I did. But let's see. Is it possible to have remainder after something that's not a life estate?
Yeah, I'm pretty sure, but I don't remember what it was.
Okay. David, you here?
Yes.
All right, David. So what do we know about a life estate? What's unique about a life estate? I mentioned it a few minutes ago.
A life estate it has a specific end time. It will end at a certain point. We know that for a fact.
Right, we all die, right?
Right.
Are there other types of interests that also have a specific end date?
Yeah, I mean, someone could set up a condition that would just inevitably have a certain end date.
Well, but is that a condition, right? If I say, you can have Blackacre as long as it's used as a farm, in theory, can't that go on forever?
Well, that could go on forever.
But what kind of interest has a specific end date? Think of our reading for today.
Oh. Well, the periodic tenancy.
What are we dealing with here? What did Ashley say that our lease is? She said it a few minutes ago. The poll question I gave you today. What kind of tenancy is that?
It was a tenancy that was beginning 1 year. So it was one that was lasting 1 year. And
What do we call that?
A term of years.
Good. Okay. So we have a term of years here, right here. Okay, David. Is there any doubt about when this lease will conclude? Is there any ambiguity?
There is no ambiguity.
Can I say with 100% certainty this will end?
Someone could re-up. Someone could add on could continue it for another year.
Sure, you can do something else in the future, sign a new lease, but this lease, as it's written, will it end on October 1st?
Yes.
Okay. It has a natural termination date, doesn't it, David?
Yes.
Okay. So then what interest does A have when you have an interest that follows a natural termination date?
You have a remainder interest.
That's correct.
Future interest that is in remainder.
That's correct. All right, let's see how you guys did. It took a little bit longer than expected, but I think we got there eventually. The answer here is remainder. 80% of you got that right. Okay? Which is very good. But I want to make sure you understand why it's a remainder. Only one we put reversion. The definition of a remainder, right, is the future interest that follows the natural termination of an estate, right, where there's a natural end point. If it's like a fee simple determinable, it can go on forever. If there's a fee simple subject to an executory interest, it can go on forever, right? If there's a fee simple subject to condition subsequent, it can go on forever. The entire purpose of the defeasible estates is they can go on forever unless the condition's triggered. But a life estate cannot go on forever. Everyone dies. A term of years cannot go on forever. The date, what's called a date certain, will be reached sooner or later. So when you have leaseholds, right, and you have a term of years, you need to think of that almost as if it were a life estate, which is why I think Ashley made a good comparison. It wasn't right, but I think she made a good comparison because it follows naturally. And the future interest after this term of years is a remainder. Chris asked, is it a vested remainder? Absolutely, right? A is ascertained, and there's no condition subsequent. There's no condition precedent. Naturally, on October 1st of the next year, it goes to A. And A has it as a vested remainder in fee simple. How do we know it's in fee simple? It says to A and his heirs. Okay? Now, why did I lead class off with this? Because what we've learned about future interests applies equally to both the feasible estates and leasehold estates. And for your exam, I can mix and match, right? I can give you a single conveyance that has both freeholds, defeasibles, and leaseholds, all in a single question, and they all interact. All right, Anthony, I see you raised your hand.
Yeah, so for the term of years, because it ends at a specified time, it's a remainder. But for the periodic tenancy or tenancy at will, since it's undeterminable when those will end, those will not be a remainder, obviously.
It might be a contingent remainder.
Okay.
Right, because it with a contingent remainder, it may never happen, right? The condition can go on forever. So we'll get to the periodic and the tenancy at wills a little bit later, but I think you might describe it as a contingent remainder, actually.
Okay.
But the point is, it can end. There will be an end point. Okay? Okay. Questions on that? Why that's a remainder? Now, had we just said Blackacre from lessor to lessee for 1 year beginning October 1st, and I put a period there, right? I didn't give anything to A and his heirs. In that example, the landlord would have a reversion, which makes sense, right? At the end of your lease, what happens to Blackacre? It goes back to the landlord, and he can then rent it out to somebody else. So always keep in mind both remainders and reversions when you have these leaseholds, okay? Make sense? Okay. All right. Let's move on to the material for today. Excuse me. The material for today, which concerns leaseholds. You have to be careful. A leasehold is different. A leasehold is a very specific type of obligation. And it derives from feudalism, our favorite times during old age in England, where the tenant holds the property under the landlord's authority. Even think of the word landlord, like lord of the manor. It's basically a feudal term. And the phrase tenant may sound normal, but it basically meant a serf, right? A lowly person who just lived off the land. So these phrases aren't even popular in some quarters. I'll use them because that's the right phrase. But it basically suggests almost a feudal type relationship. Okay. There are 3 or 4 types of leaseholds. And I say 3 or 4 because the fourth one's kind of a weird one. So I'll say 3 or 4 just to keep your notes straight. The first type of leasehold we'll talk today is the term of years. That was the hypothetical I gave you in the poll question, the term of years. The second type of leasehold we'll talk about today is the periodic tenancy. Periodic tenancy. The third type of leasehold we'll talk about today is called the tenancy at will, W-I-L-L, the tenancy at will. And there's a fourth one, which we'll talk about as well, called the tenancy at sufferance. 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 What you might also call the holdover tenant. We'll talk about that last. But these are the four major types of leaseholds. But as we'll see, these aren't the only four. The courts have developed other kinds of leaseholds that don't fit into these sorts of categories. There are two major challenges for today's class, right? The first challenge is figuring out which bucket, which category a given lease fits into. Very often when people draft leases, they're not lawyers and they don't draft it with precision. And sometimes you might have language that resembles a couple of different ones. And the courts have to pick one of these four categories or maybe make up a fifth category. The second major challenge with these cases concerns terminating the leasehold. And the reason why this, I say is challenging, is because law students don't like to count. You have to count days or count months, and you figure out how much notice is needed to terminate a leasehold. I know you're probably laughing, oh Josh, this is so easy. We'll struggle because people can't count 6 months. And it sounds stupid, but every year people make a mistake on the exam because they can't count how many months 6 are. It sounds obvious, but I'm telling you, it's going to happen to you all. So when we have these cases, keep those things in mind. What category does it fall into, number one? And number two, how is this leasehold going to be terminated? Okay? Okay, and if any of you are having internet difficulties, here's what I'd like you to do. It's not ideal, but try to sign back in and just turn your camera off. If that doesn't help, just keep signing back in. This is on YouTube as well, so if you want to just kind of leave the YouTube running in the background, so you want to, phase in and out. But the school, for purposes of attendance, wants you here live. I think it's actually a good policy, but I understand internet connections are not ideal, especially now when everyone's watching, 4K Netflix 8 hours a day. I saw one tweet that said, "Okay, I finished Netflix." Right, you watch the entire thing. So bandwidth is just dead right now. But yes, it's being live streamed on YouTube as we speak. If you go to my YouTube channel, I actually have two cameras here. I'll freak you all out. But here's the other camera. This is going to like levels of inception right now. So basically, I can see all of you on YouTube, and I have another camera here. So I have a pretty elaborate rig. Okay. All right, Caitlin, are you here?
Yeah, I am.
Okay, Caitlin, let's start out and help me out to. Oh, that's a cute puppy. What kind of dog is that?
It's a Frenchie.
Oh, that's a cutie. All right, so help us out here. What is a term of years lease? How do we define that, please?
We define it as an estate that lasts for some fixed period of time or for some period computable by a formula.
Okay.
That result in fixing calendar dates for beginning and ending.
Okay, very good. So you said a few things that are important. Let me just repeat them. Thank you, Caitlin. It's a very, very cute dog. The term of years lasts for a fixed period of time. 6 months, 1 year, 5 years, 900 years, right? But the key point is there's a fixed period of time. Even though it's called a term of years, you can have it last 6 months. So the name is a little bit misleading. It doesn't actually have to last a year. It can last any duration. You can also convey a term of years lease by using a fixed calendar date. For example, this lease will terminate on April 1st, 2021, right? April 1st, 2022, whatever specific date. But the key point is it's fixed. It's not going to be renewed unless a new conveyance is granted. In other words, at the end of that 1 year, you got to move out. You can't try to hold over. You can't try to do a month to month. You have to basically have something else. All right. Once the term's created, it goes into effect right away. The book has some discussions about some of these really long leases, which I think it's insane. In California, leases, for example, agricultural leases can't exceed 51 years. Other types of land in California, 99 years. But in Connecticut, you have a lease given by Yale University for a farm for 999 years. So when we're all alive and well in the year 2761, my God, right? Yale will recover control of the property. Farron, are you here?
Yes, I'm here.
Farron, okay, we got puppy situation, right?
Okay, I think they stopped. I'm so sorry.
That's okay. We're all.
I think I startled them.
Oh, that's okay. Let me ask you a question, Farron. Why would anyone give a 999-year lease or even a 99-year lease? Wait, we don't live that long. We're all going to be dead in 100. I hope not. But, there's good odds we'll all be dead in 99 years. Maybe I'll also be teaching. God, Lord help me. Right? But, why would anyone give a lease of this length, of this duration?
Maybe because they wanted to make sure that the land stayed with whoever had the land for a long time.
But do you know who your heirs are going to be in 999 years? Can you even just fathom what that would even look like?
No, but maybe they wanted to retain the rent, like getting the rent regardless of whoever had it.
Right. So instead of selling in fee simple, you basically create a permanent income stream, right? Okay, that's a good example. Thank you, Farron. I don't have a good answer to the question. I always ask that question. I don't think I have a good answer. You could just sell it, in fee simple for some fixed amount of money, which you can enjoy, or you could create a rental stream that lasts, for 1,000 years. What's the one in Yale for 20 ounces of silver or something? What is it? I'm sorry, 28 ounces of silver money to be paid. I don't even know what that's even worth today. I haven't checked, but I guess it's valuable. But I think there's another more psychological reason. It's about control. It's you want people to know forever that we're actually in control, right? And when this entire exercise ends, it comes back to us. We'll have reversion eventually. 99-year leases are actually fairly common. For example, the Panama Canal was leased to the United States for 99 years. Hong Kong was basically a British protectorate, a British territory for 99 years, and it was reverted to the People's Republic of China in the late 1990s. So you have these sorts of 99-year leases in government, and eventually people, 100 years passes. But I don't think you will come across a 99-year lease too often in your practice. Maybe you will, I don't know. But I don't think I've ever seen one in Texas, but maybe they exist. I haven't come across one personally. Okay. All right. Yes, Jill, I see your hand.
Can you hear me?
Yeah, loud and clear. Thank you.
All right, perfect. So I guess my question is, you said that 99-year leases are fairly common, and I also saw in the footnote that there was another one that was for some obscene amount of time, like 10,000 years?
Yeah, you have these insane leases. Yeah, I mean, it's insane.
So, today,
yeah,
if I were to, I don't know, if I just had some obscene amount of money and I wanted to buy a library, and in the lease, can I say that it's for 10,000 years?
Yeah.
Can I do that in 2020?
I mean, look, yeah, Jill, so let me answer your question this way, right? Let's say that, you want to endow a library and you want it to be in control for 1,000 years. In theory, that lease can be signed, but at some point, people will forget about it, right? At some point, it'll just get lost to the sands of time who the landlord even is. So it's almost like it's almost like one of these things that no one will remember. You do this thing just for your own sake. It doesn't have much legal weight. If you want to actually have control, you can create what's called a trust, and the trust can manage the library, and that's a much smarter way of doing it. These 1,000-year leases are insane. I don't know why, but students always like reading about them. Adam, I see your hand up.
Yeah, not more so for a question in regards to the term, but could another reason potentially be just for tax purposes? Obviously, like a transition of expensive property, you would have to pay a lot in property taxes as a transfer of estates, and it would be cheaper to do a lease. I don't know. Just
It's possible, but keep in mind that if the tenant fails to pay the property taxes on a year-to-year basis, it falls to the landlord to pay the property taxes. So indeed, by giving a lease rather than a fee simple conveyance, the landlord's on the hook for a lot more.
Gotcha. Thank you.
Yeah, Chance, I see your hands up.
Yes. So when you have a contract like that, at least in the modern application, so say you're living in a house that is leased, and then someone buys that house from the current owner, the lease still continues. When you have one of those properties where someone's gotten an agreement where it's like a 10,000 year lease, but then for some reason that owner can no longer pay property tax, whatever, the owner can't own that property, but the lease is still for that property. Who is that? Is that lease, is that agreement, does that really tie the owner down, or is that really tied to the property?
No, I mean, in theory, I mean, this is the case in the Garner versus Gerrish case, right? If a given landlord is out of the picture for whatever reason, someone has to own the property. Maybe it will be owned by the state, maybe the bank will own it, maybe the county has a sale, but the lease is valid. And when you buy a piece of property, you take it with the tenant attached to it, right? You can't terminate a lease if the landlord is kicked out, right? So let's say you guys live in a building and some company buys your building. Your lease is still in effect, right? They acquired that building subject to each individual lease. Now, they may not renew your lease, which is often a problem, but at least for the remainder of the year, you get to stay where you are. That make sense, Chance? And is that a dog on the floor I see?
Oh, yeah.
Okay, if he wakes up, we'll just no, it's okay. Alan, save us. Go ahead, Alan.
My question was, would another reason be that because there's no notice required for a term of years, that the landlord could terminate the lease whenever they want, and the reason they give a term of years is to have that option available instead of a...
Yeah, exactly right. And actually, Alan just answered my next question. You can't end a term of years before the period, right? It ends on year 10,000 whatever, right? It doesn't end a minute before. No notice is required. So on October 1st of 2076, whatever the year is, right? The lease is over. There's no notices required. So in theory, having a long period ensures that everyone knows when the thing's going to end and they can get their affairs in order. But still, like a 10,000 year lease, I don't know. Where was society 10,000 years ago, or like 8,000 BC? I don't think the Egyptians built the pyramids yet, right? We're prehistoric. It was a long time ago. Everyone loves this topic. I don't know why. It always gets so many hands. Yeah, Ashley, go for it.
So what if during a term of years, like for example, like I go from Lessor to Lessee for 1 year beginning October 1st, then to A and his heirs. What if the leasee dies during that term? Would it go back to the landlord and technically be like a reversion situation? Or would it then go to his heirs even though the term was not fully up?
No, the death of the tenant would have no effect on the duration. I think it would just the heirs of the tenant would just basically step in and live there for the rest of the lease. It doesn't leave.
Oh, okay, perfect. Thanks.
Yeah. Okay. Any other questions of the term of years? Again, there's no notice is required to terminate because it has a fixed end date.
Professor.
Who's that?
Anthony.
Okay, just raise your hand so I can just make sure I see who that is. Okay, go ahead, Anthony.
So
virtual hand that is. I can't see your actual hand.
My bad.
That's okay.
So you said that the heirs would just step in, but you wouldn't be able to say that they would have fee simple yet until the lease was over?
No, they would never have fee simple. They simply have the leasehold for whatever the 6 months, 8 months, whatever's left.
And then after that duration ends, then they would get fee simple.
Yeah, exactly. Yeah, the lease lasts for 1 year no matter what, no matter who's there. Okay. Any other questions? Yeah, Juitza, go ahead.
Yes. So cannot end before those term of years? Is that what?
Right, the landlord can't terminate it early.
Okay, so the landlord cannot terminate it early. In the book it said, but it can be terminable earlier upon the happening of some event or condition.
Yes, well, no. I mean, if you don't pay your rent, they can kick you out. Right?
Okay, so that's the type of event. Or
yeah, I mean, the landlord can't, by discretion, just say, you know what, I don't like you anymore, I'm going to kick you out. Right? If there's let me make that point clear. Thanks, Juitza. If there's a failure to pay rent, I don't care what kind of lease you're in, they can end it early. Right? That's always a ground to terminate a lease if you fail to pay rent. Usually with the term of years, you pay it annually or you can be paid up front. It can be done either way. Assuming you're up to date with your rent, they can't terminate it arbitrarily. Thank you, Juitza. Tim, I see your hands up.
Yeah, so just kind of tying it back to the poll question, in analyzing what type of lease you have, would it be appropriate to say that they would have fee simple in the present interest of whatever powers they have?
No. Don't say fee simple.
Okay.
Fee simple.
Because you wouldn't have fee simple over the property.
No. And I used a phrase earlier, a freehold estate. It's a phrase which doesn't make much sense, but freehold estates refer to all the fee simples, right? The feasible estates refers to like fee simple determinable that can be cut short. And leasehold estates are a third category. These are each three different categories, and I would not overlap them. Okay, makes sense? Thank you, Tim. Anyone else on the term of years? People love this 990 years stuff every year. It's always like so. Yes, Elias.
So if there's no third party and it goes back to the leasehold, then it's a reversion. If not, if there's a third party, then it would be a remainder, right?
Say that one more time. I think I missed you in the middle.
So if after the term of years, there is no third party that gets the property afterwards,
Yeah.
then the future interest would be a reversion.
That's right. To the landlord. Exactly.
Just making sure.
Very good. That's right. Thanks, Elias. Okay. Any other questions? All right. Actually, I think, Alan, are you next? I think you're next.
Yeah, I'm next.
Okay. Alan, help me out here. Let's go into the next category. Excuse me, the periodic tenancy. Can you tell us, please, Alan, what is a periodic tenancy?
All right, so a periodic tenancy is a lease for a period of some fixed duration that continues for a succeeding period until either the landlord or a tenant gives notice of termination.
Okay, very good. Alan, can you give me an example of what a periodic tenancy might look like? Just the words that we use to create one.
To A from month to month, or to B from year to year.
Perfect, right. The definition of a periodic tenancy is that it doesn't end at a specific point, right? The term of years ends at a specific point. However, the periodic tenancy doesn't have a specific end date. It is continued for certain durations, which might be a month or it might be a year. And it will go on and on and on and on and on until either the landlord or the tenant gives notice of termination. Again, the periodic tenancy lasts for periods of fixed duration. It might be a month or a year, and it continues for each period, 1 month, 2 month, 3 month, 4 month, etc., until either party gives notice of termination. Death of the landlord and tenant has no effect. It survives the death of the current tenant. So if you actually create a periodic tenancy, in theory, I could live there, my daughter could live there, her daughter could live there, until either party gives notice. What makes these difficult is that they extend automatically in the absence of notice. Again, if there's no notice given, it goes for another month, and another month, and another month. So the difficulty of the periodic tenancies is how to terminate it. Specifically, how much advance notice is needed to terminate. All right, now let me clear up a few things that usually trip students up. Before class today, I suspect a lot of you stayed beyond your lease and did a month to month. Did a lot of you do something like that? Right? I'm seeing heads shaking. Yeah. You had a 1-year lease and you said, hey, landlord, let me just say another month or two, and they gave you a month to month lease. Okay. What they actually gave you was not really a month to month. It was actually tenancy by the sufferance, right? That's the fourth category I mentioned earlier. In our class, when we use the phrase month to month, we're not talking about what happens at the end of a fixed lease, right? Almost all of you probably have a 1-year lease. I think you do at least. I usually did when I had apartments. Those are terms of years, right? And they end at a certain date. The landlord can choose to let you hold over, but that's different than a periodic tenancy. And I want to just make sure it's clear. A periodic tenancy is at the outset. You say, I'm going to be here for 1 month, 2 month, 3 month, and we can terminate at any time. That isn't what most of you have. So just try to keep the terminology straightforward. Oh, and to answer your question, yeah, I shut down the reef. After I did my poll question, I don't keep it open because just the one more thing on my screen I don't worry about. Nick asks, in a periodic tenancy, it is inherent that both parties must possess a means of terminating the lease. Well, Nick's asking, what about if one party has the right to terminate? We'll study that in the Garner versus Gerrish. That's the case we'll study in a few minutes. Okay? So everyone get the general gist, right? It goes 1 month, 2 month, 3 month, and goes on until one party gives notice. Okay. Mackenzie asks, for freehold estates, we call the remainder in fee simple. Well, actually, Mackenzie, if you go back to the question I used, it was a remainder in fee simple, right? The future interest was actually, if you just go back to the question, I'll pull it up and read it for you one more time. I'll paste it in the chat so you have it for quick reference. It said Blackacre from lessor to lessee for 1 year, beginning October 1st, then to A and his heirs. In this case, after the 1-year lease, A is a fee simple. So this is remainder in fee simple like anything else. But I wouldn't describe the lease as a fee simple. That's the distinction. Right. Right. No, in this example. Now, Blake, is that you trying to raise your hand? Blake?
Yeah, did Mackenzie's question get answered?
Yeah. Did you see the raise hand button in your screen? Makes it a little bit easier if you push that.
I don't have it because I use dual monitors and it takes over all monitors if I use the
Okay.
application.
Okay, that's fine. Go ahead.
So, a lot of rental contracts have what you would probably consider a term of years. But what if they have those conditions of you have the option of renting for the full year, and if you don't choose to terminate, then it moves to a month to month. So it wouldn't exactly be sufferance if it.
Well, I get what you're saying, but if it was actually a month to month as a term is legally used, your landlord could cancel you in the middle of a month. Right? In theory, your landlord could say on, the 14th of the month, okay, you have to leave, at the end of this month. And that's not usually how it's done in most contracts. It means you stay for a full month. So basically it's creating a sufferance, basically a kind of a holdover agreement. I know what you're saying. Try not to think of how you've seen it in your own leases, because it's not exactly how the law would describe it month to month.
Yeah, and I think we're going to hit the topic later of different statutes providing different ways.
Yeah, oh yeah, we'll get there in a minute. And a lot of this actually is not common law anymore, right? A lot of this is actually set by statute. And because it's set by statute, what I'm saying doesn't really matter for common law, for the modern approach. All right, Anthony, your hand's been up as well?
Yeah, I just kind of wanted to clarify. So for a periodic tenancy, what's the reason that it wouldn't turn over into a holdover? So like a holdover would
It
only
would.
happen-
It would at the end of it. Well, you wouldn't need it because the holdover would only follow the term of years, right? You wouldn't need a holdover with periodic because with periodic it automatically renews indefinitely.
Okay, that makes
Right.
sense.
Whereas with, say you have a 1-year lease and your landlord says, fine, you can say 2 more months. That's sufferance. It's not a periodic because periodic would automatically renew. So it doesn't fit the normal definition of a periodic tenancy.
Okay.
Let's do it. Let's do an example. If you go to page, yeah, let's try this one. Go to page 462. Problem number 1. I think who's next? Is Thomas next?
Yeah, I'm here.
Okay, Thomas, do you want to read for me, please, on page 460? What did I say? 462. Problem number 1.
On October 1st, L leases Whiteacre to T for 1 year beginning October 1st.
Okay, so just stop right there. How do we characterize that lease? T for 1 year beginning October 1st. What kind of lease is that?
Term of years.
Okay, how do you know it's a term of years?
Because it has a set end date.
Okay, very good. All right, that's the first important point. When you have a lease with a set end date, it's a term of years. All right, do you go by Ryan? I'm sorry, I don't know what your names are.
Yeah, I go by Ryan.
Okay, well, I'll call you Ryan. I'm sorry. The role says Thomas. This is why I use the 10 cards, by the way, because I don't really care what your real names are. It doesn't matter to me. All right, so keep reading. Read the next sentence. On the following.
Following September 30th, T moves out without giving L any notice. What are L's rights?
Okay, so we have a term of years that began October 1st. When would it end?
Let's see. So September 30th.
Yeah, exactly, right?
Yeah.
Was there any requirement to give notice on September 30th with a term of years?
No requirement.
Okay, that's exactly right. Is the landlord, does he have any problems with that?
No, it was ended properly.
Okay, very good. Thank you so much. So this is a classic example of a term of years. You have a 1-year lease. He's there for a year. On the exact anniversary, he moves out. Peace. He's done. He's good. There's no problem. Okay? But the rules are a little bit different for a periodic tenancy. All right. Let me first give you the common law rules. And then I'll give you the modern approach. As you can probably guess, the modern approach is easier. The common law approach is more complicated. Right? Dylan asked, would it technically end the following September 30th or October 1st? I know what I get the question, but I think it would technically end basically September 30th at 11:59 p.m. if that makes sense. So we'll just call September 30th and be friends here, right? It's 1 full year. We're in a leap year this year. It's 366 days. These things are somewhat complicated, but we'll just say September 30th at 11:59 p.m. I think that's when the lease would actually conclude. All right. Let me give you the common law rule first. When you have a 1-year lease, right? When it's a lease. Let's start again. When you have a periodic tenancy that lasts 1 year, at least 1 year, you're required to give 6 months notice. Again, if you have a periodic tenancy that lasts at least 1 year, it's required to give 6 months notice. Okay? So I'll give you an example. Let's say you have a periodic tenancy that begins January 1st. January 1st. Okay? If you have a periodic tenancy that begins January 1st, you're required to give notice on July 1st. Okay, again, if you have a periodic tenancy that begins January 1st, and let's say it's year to year, you're required to give notice on July 1st. Why July? It's half of the length of the period. If the period's 12 months, you need to give 6 months notice. If you fail to give notice on July 1st, the period automatically renews. Yes, Nick, it's year to year. If you fail to give notice by July 1st, it automatically renews, in which case you're now on the hook for another year of rent. Tim?
And when you say a 1 year lease, this does not mean year like rent collection schedule, right? Like, is it like the rent is paid once a year?
You can do it. I mean, usually you pay rent monthly, right? But you could have a year-to-year lease where the rent is due on January 1st and you pay the full year. Okay? So again, with a periodic tenancy that lasts at least a year-to-year lease, for example, you need to give 6 months notice. Okay? What about, Blake asked, would it be before July 1st? This is why, this is why this topic always gets confusing. I'm just going to say July 1st, keep it easy, right? But technically, it would be basically June 30th, 11:59. But we'll say July 1st, keep it simple. Okay, you're not wrong. You're not wrong here. Okay. What happens if the lease is less than 1 year? So let's say you have a month-to-month, right? A month-to-month lease. At common law, the notice must be given equal to the length of a period, not to exceed 6 months. So let's say you have a month-to-month lease. That means your period is 1 month. Okay? So if your month-to-month lease began on January 1st, and let's say you give notice to terminate on March 20th, that's not good enough. Your earliest termination date would be the end of April, right? You'd be on the hook for April rent. Again, you have to notify your landlord on basically the first of the month, the first day, to give a full period. Otherwise, there's an entire new month of liability. Everyone get that? Okay, so for common law, if the lease lasts at least 1 year, you have to give half, 6 months notice. If it's a periodic tenancy that lasts month to month, you need to give it one full period, which is basically a month, so the first of the month. Okay, that's common law. Modern is much easier. 30 days notice. Real simple, right? When you give 30 days notice, the lease ends 30 days from that date. You're not required to pay a full additional month. Okay. Michael asks, say again. Okay, I'll try. Doug asks, so in a modern jurisdiction, month to month will be 30 days as well. But just to be clear, in a modern jurisdiction, which is basically every state in America right now, it's 30 days notice, right? You can give notice on the 15th of the month, and it will end the 15th of the next month, right? You're not required to pay a full month rent. That's what the modern rule is. And let's try a question. Who's next? Stuart, are you here?
Yes.
Okay, Stuart. So if you go back to page 462, it says, what if the lease had been to T from year to year, beginning October 1st? Again, it says, what if the lease had been to T from year to year, beginning October 1st? What kind of lease do we have there? What kind of lease is that?
Periodic tenancy,
Okay, how do we know it's periodic?
because there's a fixed expiration, and there would need to be a notice to terminate.
Well, no. What's the definition of a periodic tenancy? What is the definition of a periodic tenancy?
It's a lease for a period of time with a fixed duration that continues for succeeding periods until the landlord or tenant give notice of termination.
What words in this conveyance tell you that we have a periodic tenancy?
There's been no fixed term.
What? Read it again. What's the conveyance here? Read it.
I'm sorry, I think I lost your place.
You're in problem one.
Problem one.
The sentence begins, what if the lease?
What if the lease had been for no fixed term?
No. What if the lease had been to T from year to year beginning October 1st? Do you see that?
Okay, yes.
What language in that sentence tells you that you have a periodic tenancy?
From year to year.
Okay, that's all I needed, right? Okay, so we have a periodic tenancy. So Stuart, how much notice is needed with a periodic tenancy in this case? Assuming we're a common law rule here.
6 months.
Why is it 6 months?
Common law, you need 6 months notice to cancel a 1 year lease.
Right, okay, good. So you need 6 months notice. When would you have had to give notice in this case to terminate it at the end? What date would you have to actually give notice by?
May 1st.
That's right. May 1st is 6 months before October 1st, right? You have to give notice May 1st. Stuart, was there any notice given in this case?
No notice was given.
So therefore, what happens to the lease on October 1st?
With no fixed term, let's see. It's still periodic tenancy.
Right.
And it's going to continue.
Until
the tenant terminates?
No. When will it continue till? This is the important point. When did the lease begin?
October 1st.
So when will it continue until?
October 1st.
That's it. You're done. Thank you. Right? Because notice was not given on May 1st, that is 6 months before October 1st, it automatically renews for another 1 year period. Right? It automatically renews for another 1 year period. Okay? Everyone get that example. If you have any questions, just raise your hand now. And I know a lot of you putting the questions in the chat. You can raise your hand also and say it. It's a little bit easier to talk to a person. So Ryan, you wanna ask your question?
Yeah. My question was, is it also only a 30-day notice for modern law if it's a year-to-year?
Yes. Yeah, right. So under modern law, it's 30 days. But let me just caveat, the 30-day is for residential leases, right? Commercial leases are a different story. And usually you don't find many year-to-year leases for residential. Usually the year-to-year leases are commercial. So different rules for commercial properties. Okay?
Okay.
All right, who's next? Allison, I think you're next. Yeah, Michael, did you want to say something? You popped in quick and you popped out.
Yeah, you said commercial leases are different. Do they require a different notice?
Usually, yeah. Yeah, usually the leases have specific notice requirements. So imagine like you're renting like a warehouse or a factory. 30 days might not be sufficient notice for like a huge facility. Thank you. All right, Allison, you're back. Can you read number 2, please, on page 462 at the bottom?
Yes.
Thank you.
T, a month-to-month tenant, notified L on November 16th, 2012, that she would vacate as of November 30th, 2012.
Good. Keep going.
So, keep going. Okay. T subsequently vacated on that date and paid no further rent to L. L, after reasonable efforts, finally relet the premises beginning April 1st, 2013. The jurisdiction in question has no statute prescribing the method of terminating a month-to-month tenancy. L sues T for unpaid rent for the months December 2012 and January through March 2013. What result?
Okay, very good. Excuse me. So we have here common law jurisdiction, right? It tells us that the jurisdiction has no statute. So first off, Allison, what kind of lease do we have here? Is it periodic or term of years?
Periodic.
Okay, very good. How do you know that?
It says month to month.
Okay, very good. How much notice is required for a periodic tenancy at common law?
For month to month, it is like 15 days half the lease.
Okay. Say it again. I'm sorry.
For month to month, it's equal to the length for the period.
And how long is the period here?
30 days.
Okay, so if you give notice on November 16th, when would your lease actually end? Would it end on November 30th?
No.
When would it end?
December 30th.
December 31st, right? Yeah, exactly.
Oh, yeah.
No,
Sorry.
which is why the counting always trips people up. But yeah, basically 30 days has September, April, June, and right, all the way 31 days in December. So the lease ends on December 31st. So Allison, is the tenant liable for rent for December?
Yes.
Is he liable for rent from January through March?
No.
That's right. Exactly right. Thank you, Allison. There's no reason to penalize the tenant for the time in which the landlord couldn't rent it. But he is in the hook for the December rent because he failed to give adequate notice. Tim, you want to read your question? It's really long. It's quicker for you just to read it and tell us what you're thinking.
Oh no, I was attempting to answer Anthony's question. He was asking about the automatic renewal, and yeah, you'd be on the hook for the following period.
Yes, you would. Yes, you would. Okay, thank you so much, Tim. All right. Any other questions in the periodic tenancy? Again, the hardest part of this is figuring out how much notice is required at common law. And if you fail to give enough notice, you're on the hook for another period. That's the hardest part of this topic. Okay. Questions on the periodic tenancy? Okay, let's move on to the third category. Juitza, tell me, what is the tenancy at will?
A tenancy at will is a tenancy of no fixed period that endures so long as both landlord and tenant desire.
Okay, in your own words, what does that mean?
So it's as long as it's kind of both kind of decides when they terminate the lease.
Mm-hmm.
It also makes a note about it's at will of one of the parties as well as the other. So that I was kind of confused about that. So if it's unilateral or not.
Yes, you're right. But let's just, Juitza, let's rule out. Is there a fixed end date for a tenancy at will? Is there a specific end date?
No.
Does it renew for periods at a time, whether a month or a year?
No.
Okay. All right, thank you. That's what I want to get out, right? The tenancy at will differs from the periodic tenancy in that there's no fixed end date. The tenancy at will differs from the periodic tenancy in that there's no automatic renewal. The tenancy at will, in theory, goes on not forever, but for a very long time. Okay, now the easiest way to end a tenancy at will is death. I think Ashley asked me earlier in class what happens at death. With a term of years or periodic, death doesn't discriminate. It's a line from Hamilton, right? Death doesn't matter with periodic or terms of years. But with the tenancy at will, death matters. At the death of either the landlord or the tenant, the lease terminates. Okay? It terminates. In terms of notice, what if people don't die? They're still alive, right? Most statutes require 30 days notice to terminate a tenancy at will. So if the landlord gives 30 days notice, tenant's got to go in a month. If the tenant gives 30 days notice, then he's still on the hook for that rent. Okay? You need to have some sort of notice. Yes, Caitlin, I see your hand.
Yeah, sorry, I was just going back to the periodic tenancy. And this might be a stupid question, but say it was a year-to-year lease, and on say the lease began on January 1st, and then you gave notice on July 2nd, therefore it would be after that time. I know that you'd be on the hooks for the following year, but do you need to give notice the next year that you would like to?
No. Once you give notice, that's it, and you're on the hook for one more year.
Okay, and only one more year, and then after that,
Yep.
you only notice once.
Yep, you're given your notice to vacate, and it takes effect the following year. Exactly. Your puppy's very well behaved. I used to do my puppy passed away about almost a year ago, but she would be on my lap for interviews, and she would occasionally pop her head up and just start looking around. It was cute. What's that?
I said he's just passed out snoring. So.
Okay, too much running around. Yeah, all the dogs are happy getting walked nonstop because people need to go outside. I understand. All right, thanks, Caitlin. The tenancy at will, though, is complicated for a reason. Thank you, Ashley. Who has the power to terminate? Now, there's some easy cases, right? You might have a tenancy at will where it says both the landlord and the tenant can terminate. But what happens if you have a lease where it says only the tenant can terminate? Should the landlord also have the power to terminate? Or is the landlord stuck forever with the tenant? And that's the issue in Garner versus Gerrish, a 1984 case. Who's next? Genevieve, you here?
Yes.
All right, Genevieve, you want to give me the facts in Garner versus Gerrish, please?
Yes. So the tenant and the landlord executed a lease on a printed form, and they wrote it in themselves because there was a fill in the blank. And the rent for the property was fixed at $100 a month. And with respect to the duration of the tenancy, the lease says it shall continue for and during the term of quiet enjoyment from the first day of May 1977. And it says that it gives the tenant the privilege of termination and the agreement at a date of his choice, and it also gave the landlord a right of re-entry if the rent wasn't timely paid.
All right, Genevieve, so let's just focus on this language, right? This was a form they got from a book somewhere, right? These were not attorneys, were they?
No.
Were they legally sophisticated?
No.
Okay. And they wrote in stuff by hand, right?
Yes.
So if you just read this passage, right? The lease shall continue from the 1st of May, which term will end. Lou Gerrish has the privilege of termination. What do you think the drafters intended just by looking at this language? What do you think their intent was?
Probably that it was to last for either 6 months or a year.
Okay.
That's when he put it out.
Could the landlord terminate it at any point he wanted?
Not from what they wrote, but they probably intended that.
But is it clear that the tenant had the power to terminate?
Yes.
Okay. All right. Thank you, Genevieve. Appreciate it. So we look at this language and we realize why people hire attorneys, right? Because they think what they're doing is clear, but often they write things in very unclear fashions. But I think just reading this, they wanted Lou to have the power to terminate, but the landlord didn't. In other words, this gave Lou security that he could live there as long as he wanted. Basically, it's a life estate. unless Lou decides to move out, right? Lou can have it for life if he wants, or maybe not. The challenge becomes, how does the court characterize this? So, Tim, are you there?
Yes.
So, Tim, tell us about the English rule. What was the rule in England where you had one of these leases where the tenant had the power to terminate, but it didn't give the landlord the power to terminate? How did the English courts interpret that?
Well, the English courts had said that if the tenant does, then it's implied the landlord does as well.
Why is it implied?
Because I don't know the reason. That was just the rule.
Why do you think it was implied?
Because they're the landlord. They should always.
Yeah, okay. Yeah, I think that's right, Tim. Yeah, basically, in England, the court said, "Wait a minute, this isn't right. If the tenant has the power to terminate, that means the landlord does as well, even if the contract was silent on that front." Now we learn that the American states adopted, right? They adopted this rule. And the common law in America became that both have the power to terminate. All right? But we have next, Samia, are you here?
Yes.
Does the New York court here follow the English rule, the common law rule?
No, they don't. They said that whatever it says in the contract that the lessee can terminate, so that is what's right.
Okay. So they said we'll just follow the text of the contract. So what kind of lease is this then? We listed 3 categories so far. How does the New York court characterize this one, Samia?
Tenancy at will.
Well, but a tenancy at will would mean that either of them could terminate it. How does the New York court label this conveyance between
it says tenancy terminable at will.
There's a phrase you've never seen before. It's sort of weird. What do they call this? Well, Samia, let me ask you this. How long could this lease last for? What's the longest it could last for?
For life.
Whose life?
Sorry, what?
Whose life will it last for?
The life of the lessee.
Right, Lou's life. Can it end before his life?
It can if he wanted to terminate it at any point.
So it's almost like a kind of a life estate, right?
Yeah.
What does the court call it? They give it a phrase. Begins with a D. Don't put the answers in the chat when people are trying to find it. Thank you.
A life.
All right, I'll give it because we're running a little bit short on time. A life estate determinable. A determinable life estate. Now,
okay.
Samia, what does determinable mean? We use that phrase before, determinable. What does that phrase mean?
That basically whenever they decide to change, like either the conveyance of it, that they can.
Okay. The word determinable, thank you, Samia. The word determinable means cut short, right? Determinable estates, defeasible estates. You cut short, remember fee simple determinable? Basically, this is a life estate that can be cut short by Lou. But it's not a life estate because you have to pay rent. Usually with a life estate, you have it, it's yours. You don't have to pay rent. So basically the New York court made up another category of leaseholds, right? A life estate determinable or a determinable life estate. That's not a thing. Now it is. So one of the difficulties of this topic is how to slot a given lease into one of these 3 or 4 categories. and it's not always clear you can. So what happens here is New York basically creates a brand new category. Well, it's not a tenancy at will because only one party can terminate. Therefore, it has to be something else. It's a life estate determinable. I don't know if that's even a real thing. It's kind of like not quite made up, but more or less made up. All right. Questions on the New York case? Questions in the New York case is life estate determinable business. All right. Allison, I see your hands up.
So if you gave us a case that said that we're in New York, is this an option?
Yep, it is. Absolutely
And
it
if
is.
we're in Texas, it's probably not.
You know, I haven't seen any Texas cases that use this phrase. They might exist, but I'm not aware of any. Yeah, so Naveen asks, are life estate determinables part of modern law? Yeah, I think some states have adopted something similar to that. It's sort of a weird concept, but I know that some states have. I haven't seen it in Texas, but that doesn't mean, you know, it might exist somewhere else. Okay. Yes, Chance.
How does it work out?
Your dog's gone. What happened to your dog?
She's on the bed still.
Oh, he's on the bed now. Okay, I see. Okay, she moved. All right, good.
How does it work out if you're in New York, rent's really expensive, it probably goes up each year. If the owner of that place gets, he can't pay his taxes or whatnot.
Too bad. Too bad you made the deal.
And so he can't pay his taxes. The city or the bank repos it or whatnot. Does the city or the bank still have to honor that lease?
Well, that's what happened here, right? The landlord acquired the property from someone else. So I think, yeah, you honor the lease.
And like from an individual, a private sector, I agree with that. But like,
I don't think it would matter. I think you're stuck with the lease. Yeah, I know it's a rough deal. This is why these leases are not very popular. You don't see them very often because they can last forever, or at least not forever, but for a person's life. Let me move on. We have the last category I want to cover before we finish class today. Chelsea, are you here?
Yes, I'm here.
Chelsea, could you tell us, please, what is a tenancy at sufferance?
Okay, so with the tenancy at sufferance, a tenant remains in possession or holds over after the termination of the tenancy.
Okay. Now, what happens, Chelsea, what are the options after a person holds over? What could the landlord do?
He can opt to evict and sue for damages or consent either expressed or implied to the creation of a new tenancy.
Okay, good. Eviction is what we might call self-help, where you basically throw the bum out. You can also go to the courts to get an eviction. But Chelsea, what happens if the landlord does not evict and lets him stay there and maybe keeps accepting the rent check every month? What does that effectively do?
It creates the holdover.
Right. It creates basically a periodic tenancy, right? It's not exactly, but it's basically each period they accept the money is another period of the lease. The new tenancy might be subject to the original terms of the lease. Okay. At common law, this was fairly, this was at the discretion of the landlord. But under modern law in California and some other states, it's statutory now. That staying over effectively creates a month to month. And the landlord, for example, can't increase the rent in California when it's a month to month rent. Right? There are actually limits on the ability to increase rent. In other cases, the landlord can say, fine, you can say month to month, but here's a new rent, and it's even more. So one of the big issues is what is the rent after you have the holdover. Okay, thank you so much, Chelsea. A few other points I want to mention here. One of the difficulties with the month-to-month situation, the holdover, is what if you already rented the apartment to someone else, right? Let's say I signed a lease to move in April 1st, and the previous tenant hasn't moved out. I may not have an apartment to move into. So it creates a lot of difficulties when the landlord has to basically penalize the incoming tenant. Okay. Questions in the sufferance. It's not really a fourth category, but it usually files at the end of a term of years lease that doesn't end as was expected. Okay. Let me continue. Leases must be in writing if they're longer than 1 year. Usually, almost all leases are in writing, but they have to be. You can have an oral lease for less than 1 year. Why? The Statute of Frauds. I just say that, and I can just see the chills that go down your spines, right? It's just these awful memories from contracts. The Statute of Frauds. All right, the Statute of Frauds requires a writing. Leases are not governed by the laws of contracts in their entirety. Leases also aren't really like land conveyances. They're sort of a category into themselves, where rental properties are considered in a very different category than regular fee simple type conveyances. They're very different. There's a lot of contract law built into landlord-tenant law, which we'll study later, but they're not exactly contracts. There's some other differences we'll talk about maybe in the next class. All right, any questions on that? All right, let me talk briefly about the discrimination stuff at the end of the chapter. Most law students are not exposed to statutes. All you're exposed to is common law stuff and maybe some codes. Modern discrimination law is all statutory. We have federal discrimination law and also state discrimination law. The most important federal law is called the Fair Housing Act, which was passed in 1968. We also have the Civil Rights Act of 1866. These laws prohibit certain types of discrimination in housing. The 1866 Act prohibits racial discrimination for selling, leasing, and conveying real and personal property. The Fair Housing Act is much broader. It doesn't only limit the sale and leasing of property, it also restricts advertising. So, for example, you can't put an ad in a newspaper saying, "I want only white tenants," right? That'll be prohibited. The Fair Housing Act also extends to religion, sex, family status, national origin. It's been extended to include things like disability and other matters. The Fair Housing Act doesn't apply to all landlords. Generally, it only applies to buildings with more than 4 families, right? So if someone has a basement apartment, for example, in their home, they're not subject to the Fair Housing Act. Okay? These are laws which you should all be familiar with, and I'll have to go through them somewhat briefly. But if you want, I'd be happy to do questions during office hours a little bit later. There are 2 primary ways to show housing discrimination. There are 2 primary ways to show housing discrimination. The first is what's called disparate treatment. I put it in the chat. Disparate treatment. Disparate treatment is when there's evidence that the seller intended to discriminate. So, for example, a seller says, "I will not sell my home to a black person." Or, 2 people go to buy a house, one white and one black, and the white person gets the offer even though gets the house even though he put down less of an offer, right? When there is explicit evidence that a seller or a landlord engaged in racial discrimination, you have what's called disparate treatment. At that point, the seller says, no, here's the real reason I didn't sell it to this person. But usually, when you have such explicit evidence, they lose in court. If they lose, you can get damages. You can also get what's called injunctive relief, an injunction, which perhaps could require selling the home to the person. There's a lot of fair housing litigation. It goes on quite a bit. All right. The second form of discrimination is not so explicit. It's called disparate impact. Disparate impact. Disparate impact occurs when you don't have evidence of intentional discrimination, but a policy may disproportionately burden certain minority groups. So, for example, let's say you have a policy that requires certain levels of income to live in a place. And it turns out that the landlord adopted this policy to try to exclude minorities who may have less money, right? You're effectively using statistics to show that the effect of this policy disproportionately harms certain groups. Even if there's no evidence of any sort of racial animus or racial discrimination, the statistics could show that this is illegal. Now, it's a lot harder to make a case for disparate impact than it is to make a case for disparate treatment. Right? With disparate treatment, you have evidence of racism. That's usually a lot easier. But the disparate impact cases take forever to litigate and require a lot of statistical evidence. They're hard to make those cases, and they're not very common. All right, this was a crash course in housing discrimination. I would encourage you at some point in your law school career to take a class in discrimination law. No matter where you work, in any legal department, you're going to have discrimination cases. They are so common. They're everywhere. And what you're going to see is that every organization has to deal with these cases. So learn about Title VII, learn about the Civil Rights Act of 1964, the 8th Civil Rights Act of 66. Learn about all these laws because they will come up over and over again. I realize I ran through that really quickly. I want to make sure I get you out of here on time. Are there any questions on that last part of the chapter on employment discrimination? Nick asked, what about requiring credit scores? There's litigation on whether requiring credit scores may be a form of discrimination. There's even discrimination whether requiring certain types of background checks may be discriminatory. This litigation goes on for years and years, and I won't even try and summarize it in 30 seconds. Other questions? All right, let me summarize a bit, and if you have any other questions, I will come back at 3:30. 3:30. I'll do office hours in a few minutes after. There are three primary types of leases. You have the term of years, you have the periodic tenancy, and you have the tenancy at will. You know you have a term of years when there's a specific end date. Either you have a duration or you have a calendar date. The periodic tenancy is a lease that automatically renews for specific periods, a month or a year. What makes these cases difficult is knowing how much notice to give. At common law, with a lease of 1 year, you have to give 6 months notice. And at common law with less than a year, you have to give usually a 1 month notice. But under the modern rule for leased residential leases, 30 days notice is sufficient. And the third category, the tenancy at will, means it basically goes on forever until either the landlord or the tenant gives notice to terminate, at which point the lease ends. Okay. Questions on this? No? All right, 3:29 on the dot. I'll be back in a minute. Thank you all so much and have a wonderful weekend.